All rise.
Kosovo Specialist Chambers is now in session.
Good morning, everyone, in and outside the courtroom. Mr. Court Officer, can you please call the case?
Good morning, Your Honors. This is case number KSC BC 2020-04, the Specialist Prosecutor versus Pjetër Shala.
Thank you, Mr. Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Thank you, Your Honor, and good morning. Appearing today for the prosecution are Legal Officer Bernhard Kushnick, Disclosure Officer Margot Portier, and I am Prosecutor Sean O'Dowd. Thank you.
Thank you, Mr. Prosecutor. Now let me turn to the defense. Mr. Gillissen, please.
So, good morning, Mr. President. I greet all participants in the hearing. I'm Mr. Gillissen from the Liège Bar in Belgium. I'm assist Mr. Shala, who is with us by video link, and I am assisted by Mr. Awini, my co-counsel, Mrs. Leto Karielou, and Ms. Zeneta Petrovica. Thank you very much.
Thank you very much, Mr. Gillissen. And I confirm that Mr. Shala is attending the status conference via video link. Let me now turn to the registry. Mr. Roche, please.
Good morning, Your Honor. My name is Ralph Roach from Judicial Services Division in the Registry. Thank you.
Thank you, Mr. Roche. And for the record, I'm Nicholas Guillou, pretrial judge for this case. On 5 November, I scheduled the fourth status conference in this case. My goal today, as usual, is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss disclosure of evidentiary material, translations, the status of the specialist prosecutor's investigations, the status of the defense investigations, the points of agreement on matters of law and fact, and finally, any other issues the parties may wish to raise. I thank the SPO and the defense for their submissions ahead of the status conference. And as usual, I will invite the parties to present their views in a concise fashion about each item on the agenda, which I will address individually. Let us start with the first topic that was listed in the scheduling order, which is disclosure. As I did last time, I will give the floor to the parties on the disclosure of each category of evidentiary material separately. First, the Rule 1021B material, which is the evidentiary material that the SPO intends to use at trial. Then the Rule 1023 material, which is the material relevant to the case as listed by the SPO. Then the Rule 103 material, which is exculpatory material. And finally, the Rule 107 material, which is protected material for which the consent of any provider is requested. So let me start our agenda today with the disclosure of evidentiary material the SPO intends to present at trial. The SPO indicated in its written submissions that it was preparing a disclosure of the additional Rule 121B materials, which were the subject of my 4 November 2021 decision. I invite the SPO to indicate if the material has been disclosed, and I note that there was a disclosure package on Friday, and I hope the SPO will tell us that it was the case. The SPO further indicated that there are currently fewer than 20 items for which discussions with Rule 107 information providers remain ongoing. I also invite the SPO to clarify whether any of the outstanding Rule 107 materials are evidentiary material the SPO intends to use at trial. I also invite the SPO to confirm that the remaining Albanian translations have been finalized and disclosed, and that the expert reports relating to forensic matters have been disclosed in October, according to the oral order I issued during the last status conference. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Yes, Your Honor, I can confirm that Friday's disclosure did include the balance of the Rule 102(1)B materials. With respect to the Rule 107 materials that are outstanding, I can confirm that those do not include additional 102(1)B materials. Those are 102(3) materials. With respect to the outstanding translations, they have been disclosed, and the outstanding expert reports have also been disclosed. Thank you, Your Honor.
Thank you, Mr. Prosecutor. So I take from your submissions that you are entirely done with the Rule 102(1)B material.
That's correct, Your Honor.
Thank you, Mr. Prosecutor. I like that. Let me turn to the defense. Mr. Gillissen, do you want to comment on this or add anything?
Yes, Mr. President, thank you very much. So we received very lately, but we finally received all the documents announced by the prosecutor. As mentioned in our written submission, I just have to underline the defense of Mr. Shala is reserving its right to seek the appropriate remedy for the prejudice that we suffer this late discussion. But it's too soon, of course, to talk about that at this stage. And I confirm we received the document on the basis of the Rule 102(1)B in package 17 related to the expert's report. So I don't know if it is time to talk about the notice or it's too soon, Mr. President?
The next item on the agenda.
Okay,
in a
thank
couple
you
of
very
minutes. Thank you, Mr. Gillissen. Unless the SPO wants to add anything on this, no. So let me now move to the Rule 102(3) notice and evidentiary material. The SPO filed a supplemental Rule 102(3) notice on 22 September 2021. The SPO indicated in its submissions that it provided further information to the defense regarding the items listed in accordance with the defense request to this effect. The defense provided its initial Rule 102(3) indications on 7 and 15 October. On 5 November, the SPO released to the defense Disclosure Package 22, containing 412 documents under Rule 102(3), of which 405 items relate to the defense indications of 7 and 15 October. The defense provided additional Rule 102(3) indications on 2nd November 2021, and the SPO indicated that it is currently reviewing these materials and at this time anticipate disputing the materiality of a small number of items. The SPO also anticipates submitting requests for non-standard redactions or protective measures, including for certain materials requested by the defense pursuant to its Rule 102(3) indications. I note that in its written submissions, the defense indicated that inter partes discussions with the SPO were ongoing, notably to obtain additional information on the items on the Rule 102(3) list. So I invite the parties this morning to give an update on disclosure of Rule 102(3) materials, notably whether disclosure on the basis of the defense indications of 7 and 15 October 2021 has been completed. Second, the status on the parties' inter partes discussions. And third, a detailed indication about the timeline of the future requests related to this category of material as announced in the parties' submissions. Mr. Prosecutor.
Thank you, Your Honor. You have correctly summarized the SPO's position. The disclosures of Rule 102(3) materials for the 7th and the 15th October requests are ongoing according to the schedule that's been set by the court. They're expected to be completed by this time, consistent with that schedule, Your Honor. With respect to the inter partes communications, we continue to communicate regularly with the defense about issues as they arise. and we don't anticipate any difficulties complying with the schedule set by the court for the remaining 1023 items. However, our review of those items is ongoing, but at this point, we expect to proceed according to the schedule.
Can you give any indication on the timeline for any request for protective measures?
Yes, Your Honor, we would expect that a request for protective measures would be filed by the end of this week.
Thank you, Mr. Prosecutor. Mr. Gillissen, do you share these positive and enthusiastic views of the disclosure of the Rule 1023 material?
Yes, I'm very prone to say I share this view. As you said, the SPO provide us with the necessary description that we request from them on the 22 October. The defense provided this indication in due time. I don't have to repeat all the information you provide before. So this means that just now we have the dispute about materiality or relevance on some documents required by the defense. We receive a list from the SPO concerning 12 documents that the prosecutor considers as irrelevant. And we had discussion with the SPO about the materiality of some documents. And the SPO provides us with further explanation and description of the content of certain documents. And we have reached an agreement on a partial disclosure and or irrelevance from the items. The party avoid by this process any litigation on the matter. We are scheduled to meet very soon, it means today, with the SPO to discuss the materiality of these items, and I have hopefully to continue to avoid any litigation and to deal with the matter in the most efficient manner. Thank you very much, Mr. President.
Thank you very much, Mr. Gillissen. This is very good information to the court. Mr. Prosecutor, do you want to add anything or to comment on the defense submissions?
No, thank you, Your Honor.
Thank you, Mr. Prosecutor. Let us now move to the Rule 103 material. In its written submissions, the SPO indicated that it had disclosed 3 batches of Rule 103 materials to date, and that review of potentially exculpatory materials is still ongoing. I note that there is also a new batch that has been disclosed on Friday. I would like to know whether there remain any exculpatory evidence in the SPO's custody, control, or actual knowledge that must be disclosed to the defense pertinent to Rule 103, and as usual, whether any request for protective measures for such material is imminent. Mr. Prosecutor.
Thank you, Your Honor. Yes, indeed, there was an additional batch of Rule 103 materials disclosed on Friday. In fact, there have been 3 batches of Rule 103 materials disclosed since the last status conference. The SPO's review for potentially exculpatory materials is ongoing. We continue to be mindful of our obligation to disclose them on an ongoing basis, and we're also mindful of the court's directive from the last conference to move as quickly as possible, and we're proceeding along those lines. In terms of a request for protective measures, Your Honor, there may be a request, but none is imminent at this time.
Thank you, Mr. Prosecutor. Mr. Gillissen, or Mr. Gillissen.
Thank you very much, Mr. President. Exculpatory, it's a difficult word for a French-spoken person. Exculpatory material we received from the SPO, an important batch of exculpatory evidence on the 2 November 2021, last Friday, as you said. On the 12th November 2021. So we are busy with it, and I'm afraid to say it's a little bit soon to take position about it. But we have already requested from the SPO some information and documents following a recent exculpatory disclosure on the Rule 103 in package 21. So we are waiting a response, and I'm sure it will come as soon as possible. And we continue to discuss on this matter, and I'm sure we will find a solution between us. Thank you very much.
Thank you, Mr. Gillissen. Mr. Prosecutor, I hope that you will not disappoint the defense on this.
Understood, Your Honor. Thank you.
Especially on the timeline, as usual. Thank you, Mr. Jelissen. Thank you, Mr. Prosecutor. Finally, let us now move to the Rule 107 material. In its written submissions, the SPO indicated that it has further reduced the number of Rule 107 materials outstanding, and that discussions with Rule 107 information providers remain ongoing for currently fewer than 20 items. The SPO also indicated that it will seek leave to supplement the Rule 1023 list to reflect recently cleared items, and that it is the SPO continuing to engage with providers about the remaining item. I would like the SPO to give more details on the timeline for future requests related to this Rule 107 material, and also the timeline on any future requests to amend the list. Mr. Prosecutor.
Thank you, Your Honor. I don't have a precise timeline, unfortunately, on when the Rule 107 negotiations with providers will be complete. Those are ongoing, and we're moving as quickly as possible on that. With respect to the 1023 notice, we expect to be in a position to file a request for permission to disclose an additional Rule 1023 notice by the end of next week.
Thank you, Mr. Prosecutor. And you confirm that it's less than 20 items?
Yes, Your Honor. Confirmed.
Thank you, Mr. Prosecutor. Mr. Jelissen, please.
Yes, Mr. President, I take notice, and as usual, the sooner the better. Thank you very much.
Absolutely. Let us now move to the issue of translations and of filing and evidentiary material, which is the second item in our agenda today. In its submission, the SPO indicated that it has not made any request for prioritizing, this is another hard one, Mr. Jelissen, like exculpatory, the translation of specific filings of evidentiary materials. I note that the defense indicated in its submissions that it has obtained a number of translations from the SPO, and that the parties continue their discussions related to translations inter partes. I would like to hear the parties on any further issues regarding translations, and I will start with the defense translation. Mr. Jelissen.
Thank you, Your Honor. So this is always, we know that, a very difficult matter, very delicate one, the problem of translation, and I understand perfectly the registry on the problem they could have to face. On a regular basis, we make requests to translate specific filings on priority basis. Because we need for our work with Mr. Shala, it's really a necessity, it's really a real need, and we believe it is essential that the key decision could be translated very quickly to fully inform the accused. I provide you with just one example, no need more. It's about the decision, your decisions on the preliminary motion. Till now, these decisions are not translated yet. Some people could say it's not a real problem, of course, but it means that we were obliged to discuss with Mr. Shala about the possibility of some appeal on this decision without the benefit of a full Albanian translation. So it's a real difficulty. I repeat, I understand, of course, the real difficulty we have always to face with the translation, but I'm sure that altogether we will find a solution for the future. It's a delicate situation to discuss with Mr. Shala. That's a difficult matter, of course, and difficult intense to try to discuss with him. Even in French, he has to translate it for himself in Albanian. So sometimes it's really difficult. I'm sure I will be hurt by the registry. Thank you very much.
Thank you, Mr. Jelissen. Mr. Prosecutor.
Thank you, Your Honor. In addition to the materials our defense colleagues have identified, they have also flagged to us a list of items provided by the prosecution for which they sought translations. We have provided them with all the translations we had in-house, and we have obtained translations for all the materials we are obligated to translate under the framework decision. All of those translations have now been completed but for one. Well, one was completed today. All of them have been completed and disclosed but for one. The remaining item will be disclosed very soon. For the rest of the items the defense has inquired about, the SPO has assessed that these are not the type of materials we're obligated to translate under the framework decision, and frankly, we just don't have the in-house resources to do that. And so they've indicated to us that they expect to identify some of these documents as essential items, and we've invited them to raise them with us on a case-by-case basis, and of course, we're happy to have that discussion when they do.
Thank you, Mr. Prosecutor. Before I give back the floor to the defense, I will just ask the registry on an update on translation, and if you have any request for prioritization pending. Mr. Roche, please.
Thank you very much, Your Honour. As regards the two decisions that Mr. Killison referred to, the decisions of Your Honour on the preliminary motions, they were filed or issued on the 18th of October. They're currently being finalised, and revised versions should be circulated on the 26th of November at the latest. The initial indication we gave was the end of November, so we're on course to exceed that deadline. As regards the original decision or requests made by the defence, unrevised translations have been provided in both cases, and also we are finalising the revised translation of the second request, which should be distributed very, very soon. And the revised translation of the first submission or filing by the defence has already been revised and distributed. Thank you.
Thank you, Mr. Roche. Mr. Ayuni, please.
Thank you, Your Honour. Good morning to everyone. Just to confirm what the registry just submitted about the timeline of the decision on preliminary motions, we were provided with that deadline. And it has been in the past very useful to receive draft or unrevised translations, because we could have a support with much more information than what we could explain to Mr. Shala in order to make key decisions like appealing a decision or things of the sort. So I think we can leave it at that, and obviously the sooner we can get even a draft translation will help us in our day-to-day work with those kind of filings. But I wanted to return to a specific issue that the SPO mentioned about the translation of evidentiary material. As Your Honour knows, we have made a table request to the SPO on the 22nd of September to the SPO to help us with providing us the Albanian translations or English translations of some evidentiary material when they have them, or to help us locate them. Out of a total of around 61 items, we received around 21 translations. There are 40 translations for which, as the SPO mentioned, they believe, with regard to your framework decision, that they are not obliged to translate. And we're looking at your framework decision at paragraphs 64 to 67. So we are clear that the translation of witness statements under the Rule 102.1b are those the SPO is required to translate. And then the caveat, which is at paragraph 67, that is, if the defense believes some of the items outside of the witness statements of witnesses they intend to rely on at trial would prove essential to the defense, then we can make this request. Now we've ascertained what the SPO have been helpful with providing more than what they are obliged to disclose when they have that translation. So we appreciate that. And now we have started the discussion about the extra material that is not strictly under your framework decision on the obligation of the SPO to disclose, but provided that we prove what is essential. And here we don't request anything yet from Your Honor. We will engage in those discussions. Obviously, the word essential might mean something different when Mr. Shala doesn't understand the original language in which the documents are, which is English, sometimes Serbian, also a language that Mr. Shala doesn't understand. So we will start those discussions, and maybe we will have a checkpoint on the next conference on it. We are trying to also minimize the impact and the burden by resorting to our internal capacities in order to also move quickly with the understanding of certain items or making decisions with Mr. Shala. So we will get back to that, either with deadlines or with specifications or clarifications about the framework decision in the specific case of Mr. Shala, and probably on specific items that we could justify more expansively. So thank you, Your Honor.
Thank you, Mr. Ioni. Just one follow-up question about the material that you will ask the SPO to get translation that is not under the scope of the translation that are compulsory in my framework decision. Do you have an idea of the amount of document and the amount of pages? Because of course it's different if we're talking about 10 documents of 5 pages each, or 300 documents of 100 each, because then it's a completely different exercise for the SPO and for the resources of the court. I mean, in the ballpark. I'm not asking you the exact number, but just to have a very broad idea on what are we talking about here.
Thank you, Your Honor. Your Honor is totally on point. We're not talking about thousands of items or hundreds. From the initial request of the 22nd of September, we have come down to 40 items. We don't have the number of pages, exact number of pages. 40 items for which no translation exists, and we will have to translate them either through the SPO or through the registry services or through our internal resources. So those are as we stand, and those don't include, for example, the expert reports or the additional items that have been disclosed. So we are trying to deal with those items as we can, with maximizing what we can do in terms of time and efficiency. We can report to you that for the expert reports, we have been able to, because we believe those are very important, those include some Rule 103 material, so we deemed necessary to obtain with our own resources summary translations, and also in the meantime draft or unrevised translations for us to be able to work, and rather than engaging in a more lengthy process. As it stands, on the ones we have already initiated discussions, we have around 40 items for which we will engage in discussions about the essential character of these documents to obtain them from the SPO, but that doesn't include the latest disclosures of last week. Thank you.
Thank you, Mr. Ayuni. Mr. Prosecutor, do you want to comment on this?
Thank you, Your Honor. Nothing further from the prosecution on this issue at this time.
But you agree to engage in discussions with the defense on this?
Yes, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Mr. Roche, do you want to add anything?
Thank you, Your Honor. Just one piece of information. We would not, by default, always provide unrevised draft translations when prepared, unless requested, but I can take Mr. Ayuni's comment as a standing request for all draft documents to be provided, which we will do in future. And as regards evidence, I mean, that is not something that the Language Services Unit of the Registry would be involved in translation under the appropriate administrative framework. We are primarily responsible for filings, and obviously we are concentrating on those, and there are no outstanding prioritised requests apart from the ones that I mentioned, which will be ready by the 26th of November. Thank you, Your Honour.
Thank you, Mr. Roche. The defense wants to add anything? No? No? So let me now move to the third item in our agenda today, which is the status of the SPO's investigations and next steps. In its submissions, the SPO indicated that any additional investigative steps would be completed before the filing of the pretrial brief, I'd like the SPO to confirm this. Mr. Prosecutor.
Yes, Your Honor. We can confirm that. Thank you.
Thank you, Mr. Prosecutor. Do you want to add anything on your investigations or on the pretrial brief, for which the date has been set last time and which I don't intend to change?
Thank you, Your Honor. Nothing further on either of those issues at this time. Thank you.
Thank you, Mr. Prosecutor. Mr. Gilisen or Mr. Ayuni, do you want to add anything on this?
No, thank you very much, Mr. President.
Thank you. For the next point on the agenda, I'd like to turn to the defense, because it is the defense investigations. I note from the defense written submissions its intention to carry out investigations for the purpose of the presentation of its case. The defense indicated that it has entered into agreements with persons that will be assisting its investigating efforts on the ground and in the process of determining the principal subject and timeline for its first investigative mission. I invite the defense to provide any additional information, if it wishes, on this topic. However, I also note from the defense submissions that it remains unable to provide any information on the anticipated duration or status of its investigative activities until the disclosure process is complete and the defense have reviewed and analyzed the disclosure material. I also note that the defense at this stage is not able to confirm whether it will make any request concerning unique investigative opportunities and whether it will provide notice of an alibi or any other grounds excluding responsibility. Mr. Gilisen, I give you the floor to add more detail on these submissions.
Thank you very much, Mr. President. Accurately, we finally, and I'm very prone to insist on this, we finally find some really able person to assist on the grounds our investigations. It was a difficult business, I explained it before, but we are. So we are now focusing on the principal purposes of our investigation and the timeline of this investigation. We will be able to provide more specific information for the next EU conferences, but I remind, and you told it, that we will be unable to provide some information, additional information or definitive position before the disclosure is complete and the SPO pre-trial brief, of course. But things are on the run, Mr. President. Thank you.
Thank you, Mr. Gilisen. Mr. Prosecutor, do you want to comment or add anything?
No, thank you, Your Honor.
Thank you, Mr. Prosecutor. Let me now move to the next item in our agenda today, which is the points of agreement on matters of law and fact. I would like to hear if the parties have made any progress in their discussions regarding the possibility of submitting points of agreements on law and or facts, pursuant to Rule 95 and 156 of the rules. In this regard, I note that the parties have conducted additional discussions regarding potential of agreements on law and facts. The SPO indicated in its submission that it expects to be in a position to identify certain of these issues by the filing of the SPO's pretrial brief. And I also note from the defense submissions that it awaits the SPO's first formal proposal on possible points of agreement. Can the parties give an update on this topic, starting with Mr. Prosecutor?
Thank you, Your Honor. Just very briefly, since our written submissions, we have had one additional inter partes discussion with the defense on these issues. On this issue, these discussions continue. We continue to anticipate being in a position to identify certain areas of agreement by the time of the filing of the pretrial brief. And we will submit formal proposals to the defense at a time when we think that's constructive.
Thank you, Mr. Prosecutor. Mr. Gilisen?
Yes, Mr. President, thank you very much. I confirm absolutely the prosecutor's statement. We'll still await the formal proposal from the SPO, but we are having discussion on this type of issue of facts and laws that could be debated as point of agreement or point of dispute. So it's a little bit soon, but it's the same. We are on the good way to proceed properly. Thank you very much.
Thank you, Mr. Gillissen. Before I give you the floor on any other matter, there is one point I would like to raise, which is the issue of the calendar for the next detention review. I would like especially to have a discussion with the defense to see with the defense if it wishes to request a variation of the procedural calendar for the next detention review. According to the decisions issued last Wednesday, the defense shall file its submission on the next detention review of Mr. Shala by no later than Friday, 17 December 2021, with responses and replies following the timeline set out in Rule 75 of the rules. Should the defense decide not to file any submissions by the aforementioned timeline, the SPO shall file submissions on the next detention review of Mr. Shala's detention by no later than Thursday, 23 December 2021, and the defense, if it wishes to do so, to file its submissions by no later than Wednesday, 5 January 2022. I note that these deadlines fall during the recess period. So I would like to ask the defense if it wishes to waive the right of Mr. Shala to have his detention reviewed within the 2 months deadline in order to file its submissions after the recess period. Or it can be also at least the reply to the prosecution. And in case the defense intends to file an appeal against the last decision on detention, I would like the defense to indicate if it wishes to waive its right to have the detention of Mr. Shala reviewed until the decision of the appeals chamber, as it was done in relation to the appeal against the first detention decision. I can give you a couple of minutes so that you can discuss within your team. And just let me know when you're ready.
Thank you, Your Honor.
Mr. Ayuni, please.
Thank you, Your Honor. We understand the situation where the deadlines are on both limits of the recess. The position of the defense is this. If Your Honor intends to move before the deadline, then it will be agreeable for us because it is to the benefit of Mr. Shala that his detention is reviewed before the 2 months. So it's still within the 2 months, but before. So we do it before the recess. But if the intention is to move it beyond the recess, so in the next year, then we cannot engage in that without seeking firm instructions of Mr. Shala, discussing that before with him, because obviously it delays that next opportunity to seek the review of the detention. So if the process is moved before the recess, we can safely say we welcome that, and we will be able to deal with it before the recess, and no prejudice will be for Mr. Shala because he will have his review of detention sooner than what is scheduled today. But if it is the opposite, then we would need to come back with a proposal after discussing with Ms. Shala. Thank you, Your Honor.
Thank you, Mr. Ioni. I don't intend to move the deadline before the recess, just because if I was to do that, I would have to basically start the process nearly 1 month or 5 weeks before, because when you add all the deadlines in the procedural calendar, including the deadline for me to issue the decision, then we would have to start now, or at least in a couple of days. So it would be just after. But I perfectly understand the need for you to confer with your client. So what about this? I invite you to have discussions with your client, and you make a filing on this issue. And if you can include the 2 points that I mentioned, i.e., first, if you wish the detention calendar to be moved, and if so, by which date, and also if you were to appeal the decision, if you also agree to waive exactly like you did for the first appeal that you did. And it can be both. And really on this, I'm in your hand. I'm just trying to help the parties so that we do not have last-minute requests to postpone the deadline in the middle of recess. I think it wouldn't be a good practice, and it wouldn't be in the interest of Mr. Shala, because it would create legal uncertainty for his defense team. So take your time, but I mean, as usual, when I say take your time, I don't mean take too much time. But if you can get back to me in a couple of days by a written filing, that would be much appreciated.
Thank you, Your Honor. Certainly, Your Honor, we are scheduled to meet with Mr. Shala later this afternoon. This will be one of the key points of discussions for today. We'll be in a position to give you more information on those 2 points, and we take fully your observations, because in the last 2 reviews we were the one responding to the detention, so it's more the second deadline that is involved, and needless to say, if we move all the deadlines, then we will still fall within the recess unless we move everything by 1 month. So we will try to put the filing before you, explaining and making a proposal on that 2 points. Thank you, Your Honor.
Thank you, Mr. Ioni. And as you mentioned, it's exactly that. It's the second deadline that is shorter, and for which it's probably better that it doesn't fall in recess. But I leave it entirely up to you. Mr. Prosecutor, do you have anything to add on this topic?
No, thank you, Your Honor.
Thank you very much. At this point, I would like to ask the parties whether they have any other issues they would like to raise. And as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information, so that we can move to private or closed session. Mr. Prosecutor.
Thank you, Your Honor. The prosecution has no additional issues to raise at this time. Thank you.
Thank you, Mr. Prosecutor. I'm glad that you haven't presented any request to postpone any of the deadlines. Mr. Gillissen.
Thank you very much, Mr. President. First, don't say you are in our hands. It's too delicate to have a practice with the judges in our hands. But I understand the idea. So thank you very much. But, Your Honor, I thank you for allowing us to address very briefly on the issue concerning the indictment and some changes in the confirmed indictment. I'm not comfortable, of course, to comment the situation because, as you know, the corrected indictment issued by the SPO the 1st November 2021 is still not public. So don't mind, I don't have some comments or something to say about the intent. I just have to regret that this very important document, which is a fundamental one in the procedure, is not public 15 days after its issuance. It's not, of course, something that I reproach to the registry. That's the same thing that before. I understand perfectly the difficulties, but the withdrawal by the SPO of the presence or participation of Mr. Shala in some key elements on which key charges in the first indictment was based are very important for Mr. Shala, of course, for the procedure itself, of course, but particularly for the people who follow the procedure. And I mean the family of Mr. Shala, his friend, but the medias too, of course. And as you know, in Kosovo, this case, a lot of people try to follow and are speaking a lot about it. In this consensus, I allow myself to insist that the public version of the current corrected indictment be issued as soon as possible, because the actual version of the indictment displayed on the website of the KSC and in the media does not reflect the reality of facts or conduct allegedly attributed by the prosecutor to Mr. Shala, and I shall repeat that Mr. Shala denied them. So it's very important, I'm sure. And I would like to add that the correction in the new version of the indictment should be debated during a next hearing of Statute Conference, scheduled at the time the correction, the indictment, will be public. So I thank you very much for hearing me.
Thank you, Mr. Gillissen. Let me turn to the prosecution on the public redacted version of the indictment as requested by the defense.
Thank you, Your Honor. My understanding is that the SPO has filed a public redacted version of the indictment, but if that's not reflected on the docket, we will correct that post haste.
Thank you, Mr. Prosecutor. So it seemed that if it hasn't been done, it will be done very quickly, and if it's already done, you will have access to it. So it seems that the problem will be solved very quickly. Mr. Gillissen?
Yes, we checked just before the hearing. That's why we were a little bit late. So if there is a problem, I'm sure we will solve it. Thank you.
Could it be that it has been filed but not put on the website? Could there be a delay? Maybe I can turn to Mr. Roche. Would it be possible?
Thank you, Your Honour. I would need to check the specific situation of this individual document, which I can do quite quickly. Thank you.
Your Honor, we're looking into the issue, and it may well be an issue on our end, in which case we'll correct that.
Mr. Ayouni.
Thank you, Your Honor. Just to confirm, we have double, triple checked yesterday and today. We are not in receipt of a distributed filing that is a public version of the indictment. And most importantly, on the website of the KSC, the indictment that is displayed is not the new one, and it makes a big difference in key elements that are in the public domain, where we see the name of Mr. Shala, because it explains certain elements that he believes are important to be known by the public, where terms like absence or inclusion or exclusion is involved. We see no reason to have on the public domain contents that are more than what Mr. Shala is faced in these proceedings. Obviously, he denies what is there, but there should be no case where there is more than what he is accused of. So this change has to be reflected as one of the most fundamental rights of Mr. Shala, that it is accurately, and the target of this information is obviously Kosovo, the close and distant background of Mr. Shala, and it has some significant importance that might not be sensed in the same way inside the courtroom as outside the courtroom. So we appreciate that be distributed for us to be able to discuss it on a public hearing, because there is no reason and no utility in discussing such matters in confidential hearings. and that it is displayed on the website, which is the vitrine of the KSC. So we thank you, Your Honor.
Thank you, Mr. Yuni. I don't think that corrected version has been distributed with the public redacted version, so there might be filing to do on the SPO's side. But I take from your submissions, Mr. O'Dowd, that you do not oppose the idea of filing it ASAP. It's just like an oversight on your part, maybe.
It's correct, Your Honor. We have no objection to filing one ASAP.
Thank you. So I consider that the matter will be resolved in the following 2 days, Mr. Prosecutor?
Yes, Your Honor.
And you will link with the registrar so that the updated public redacted version of the confirmed indictment be on the website instead of the former indictment.
Certainly, Your Honor.
Thank you. I consider this matter nearly resolved, and I invite the defense to get back to me by written submissions if it is not the case at the end of the week.
Just one last comment, maybe, Your Honor. For the record, it's F98, and the sooner the better.
The sooner the better. Thank you, Mr. Yuni. Does the SPO has anything to add?
No, thank you, Your Honor. No additional issues at this time.
And Mr. Gillissen, any other issue, any additional issue?
No, thank you very much, Your Honor. Thank you.
Thank you, Mr. Gillissen. I would like to ask the parties for their views on the date of the next status conference, which is currently pre-scheduled for Friday, 14 January 2022. Mr. Prosecutor.
Thank you, Your Honor. That date works for the SPO.
Thank you, Mr. Prosecutor. Mr. Gillissen?
I will provide a definitive answer because I'm afraid to have occurred assize in Belgium at this time, but it's not sure that's on the 20th of January, so I have to check, and of course I will provide very, very fastly the answer. Thank you.
And as usual, the sooner the better. Thank you, Mr. Gillissen. You will receive a scaling order in due course once I hear from you, Mr. Gillissen, if possible, in the following days. As usual, I invite the parties to make any written submissions ahead of the next status conference if they would like to raise any specific issue. This concludes today's public hearing. I thank the parties and the registry for their attendance, and as usual, I thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All right.